Hai, Assalamualaikum warahmatullahi wabarakatuh. My name is Nurul Ashkin binti Muhammad Yazid and I will start the presentation. Nowadays, we can see a growing trend of corruption, lack of integrity, cases of fraud and financial misconduct that are not limited to the private sector. Concern about poor service quality and financial malpractice are also in the increase in the public sector. Whistleblowers have always been an issue in the audit profession because they are the one who notice the wrongdoing when auditing the company. But before that, what does it mean by whistleblowing? Who is the whistleblower? So, a whistleblower is an individual who reveals private or classified information about an organization which is usually related to wrongdoing or misconduct. Whistleblowers generally state that such actions are motivated by a commitment to the public interest. Whistleblowing is the term used when a worker passes on information concerning wrongdoing. In this guidance, we call that making a disclosure or blowing the whistle. In a simple definition, whistleblowing is a voluntary act of reporting on misconduct within an organization to the third parties. The wrongdoing will typically be something they have witnessed at work. To be covered by whistleblowing law, a worker who makes a disclosure must act in the public interest. Whistleblowing assists in raising awareness of any corruption issues. So before blowing the whistle, the auditor should consider additional things. If a person reports in accordance with the definition of whistleblowing, they will be protected by the law. Therefore, you must first make sure that your case is valid. However, if a person reports something that is outside the scope of the protection, it will be difficult for them to obtain it. Next, you only need to report legitimate concern. The whistleblower channels of the company should not be used to spread complaint or make false report. Personal complaint, after all, are not covered by the Whistleblower Act unless the individual case is in the public interest. And last but not least, always remind yourself that you are not an investigator, but a witness. A whistleblower role is to report the wrongdoing as a witness and observer, not to gather evidence. Therefore, you can tip off the suspect directly and should not delay just because you want to gather the evidence. Internal auditor is crucial in assisting the board of directors and management in ensuring the whistleblowing procedure are fully effective as part of a healthy organizational culture. So what are the roles of internal auditors? Firstly, an internal auditor can operate as a communication road for a whistleblowing hotline. Having a procedure to review and prioritize complaints is important since the number of calls to whistleblowing hotline is anticipated to increase. One suggestion that an auditor might make is to ensure that all reports are noticed and replied to as soon as possible. They should then prioritize action based on the risk identified in the report. Next, internal auditor can act as investigator. Internal auditor should conduct investigation constantly, especially fraud investigation, because it is critical for the credibility of the whistleblowing program that all disclosures are responded to immediately and thoroughly investigate. They must investigate all issues in a fair, timely and private manner. If criminal activity is suspected, they can also make recommendations for future action and communicate with the police. And the most important is, the internal auditor should provide assurance to the board about the effectiveness of the whistleblowing system. Whistleblowing is an important part of encouraging an open business culture that encourages employees to express their concern. The proper culture must be in place for it to be effective. That is all from me. I will pass the presentation to Badira. Thank you.
Now we move to advantages and disadvantages of whistleblower. As we know, whistleblower is the person who will expose all illegal activities and unethical behavior. A whistleblower culture will assist them in identifying all types of potential threats, such as cybersecurity risks, and may not involve any employee misconduct at all. Being a whistleblower has benefits and drawbacks for both the individual and the organization. First, whistleblower ensure that rewards are given to the right person. It's because if a person or whistleblower who knows the right thing to do and aware of illegal activities in the organization does not report into the top management or legal organization, it allows them to be rewarded for doing wrong. As a result, by providing reporting illegal activity, we will ensure that cheating does not become a means of success. Next, culture of whistleblowing could also minimize risk and costs. Misconduct that continue for a long time, such as bribing government officials or making innocent errors that leave business exposed to the risk, will ultimately be more expensive to resolve. Hence, having whistleblower will help organizations save a lot of money and time over a long term. Other than that, whistleblowers are always protected under the Whistleblower Protection Act 2010. It purports to encourage employers to become whistleblowers if they are aware of any wrongdoing related to fraudulent or illegal practices. There are a few protections that whistleblowers will get if they make a disclosure of illegal activity, which are confidential of identity, immunity from civil and criminal liability for disclosure made, and protection from detrimental action. Okay, now we look at the drawback of being whistleblower. First, the risk of losing their job or career. It's due to some employers who are not responsible and treat the whistleblower for exposing the illegal activities in the organization. For example, they will ensure that the whistleblower will not given or hire in a related field going forward. However, employers are prevented from engaging in the certain dilatory practices. Last but not least, the allegation that has been reported may not hold up. As a whistleblower, you can only be partially aware of potential misconduct, and you might not be fully aware of the relevant legal framework. There is a risk of making an accurate allegation that cannot be supported by the law and the facts. However, because of many whistleblowing claims are initially brought into confidence, the employer may never have been made aware if your claim is unsuccessful. Additionally, you can consult a whistleblower lawyer in complete confidence to ascertain whether your allegation have enough merit to move forward.
Thank you, Nurul. I am Atira. Next, I will explain about the Whistleblower Protection Act. In Malaysia, the Whistleblower Protection Act 2010 is the law that strives to eliminate corruptions and other wrongdoings by promoting and facilitating disclosures of improper conduct in the public and private sectors, protecting those who make those disclosures from retaliation, establishing procedures for the investigation and resolution of the matters disclosed, and ensuring that the disclosed information can be investigated properly. The Whistleblower Protection Act 2010 applies to all members of the organization or employees, including interns, contract workers, temporary or permanent employees. An improper conduct complaint may be made by any employee who knows about improper behavior by another employee or by another third party who knows about that employee's improper behavior. The Whistleblower Protection Act 2010 protects whistleblowers' identities, guarantees immunity from civil and criminal prosecution, and protects them from retribution in order to encourage anyone with information about wrongdoings to come forward with possible improper conduct. Next, I will share one of the example of cases that imply Whistleblower Protection Act 2010, which is the cases of Syed Omar bin Syed Ajil versus with Institute Professional Baitul Mal Sendirian Berhad. Syed Omar bin Syed Ajil is the plaintiff, has served as the Chief Executive Officer, which is CEO of the Institute Professional Baitul Mal Sendirian Berhad since September 2014. Syed Omar, plaintiff, sought protection and remedy as a whistleblower under the Whistleblower Protection Act 2010 after disclosing the mismanagement of the funds, fraudulent activities, and poor management of the Institute Professional Baitul Mal, which is the defendant, to the Royal Malaysia Police (PDRM) and the Malaysia Anti-Corruption Commission (MACC). While serving as CEO of the Institute Professional Baitul Mal Sendirian Berhad, plaintiff observed certain suspicious financial activities by defendant's employees and believed those activities were illegal. Then, he files reports of improper conduct with the PDRM and MACC. Next, the investigations commenced in September 2015 and a search warrant was made to investigate the defendant's premises and the seizure of documents. the defendant initiated disciplinary action for alleged employee misbehavior and suspended the plaintiff from his CEO responsibilities in October 2015 in an attempt to terminate the plaintiff's employment contract. On December 16, 2015, the plaintiff filed an originating summons and a notice of application for an interim injunction against the defendant, seeking an order restraining the defendant from pursuing the internal investigation launched against him in accordance with a notice of internal investigation and an order to restore his position as the defendant's CEO. Plaintiff employment contract also was not extended without any justification by defendant throughout court proceedings during the previous year. Plaintiff resigned his job in protest and filed a complaint with the Department of Industrial Relations Malaysia because he believed that he had been fired without good reason. On January 5, 2017, the plaintiff attorney proved in the court that employees with terminated contracts were also covered by the Act. On January 20, 2017, Justice John Lewis O'Hara of the High Court Justice determined that plaintiff successfully won his plea and got the notice of internal investigations against him. Then, the judge held that the defendant had failed to prove that the actions taken against plaintiff were not conducted in retaliation for his reporting of the alleged inappropriate behavior to the PDRM and the MACC. Thus, defendant needs to pay plaintiff costs at 18,750 ringgit Malaysia. In conclusion, plaintiff Syed Omar bin Syed Ajil qualifies as a whistleblower under the Whistleblower Protection Act 2010. That's all from me. Next, I will pass to the Asmira.
Thank you, Atira. Assalamualaikum. My name is Nur Asmira and I will continue the presentation on the effective establishment of whistleblowing policy. First of all, an effective establishment of whistleblowing policy should start with law that should be amended to increase the number of organizations that are eligible to receive protected disclosures. Only disclosures made to enforcement agencies are protected under the WPA 2010 as it stands right now in Malaysia. Second, whistleblowers who occasionally reveal material to media outlets and civil society organizations should also be covered by the provisions of the Act, extending similar protections to leaks to the press or activists raise valid concerns. Third, a specialized department, preferably led by a dedicated officer, should be needed of those government entities that are permitted to hear whistleblower complaints. There should be enough assurance of independence for this department. Besides, every organization should define the categories of concerns that may be reported in accordance with the policy, as well as the channels and recipients of the reports. In addition, giving assurance to the whistleblower is protected from victimization and reprisal, as well as how the anonymity of their identity is maintained in order to encourage them to report about the misproper conduct. Next, both employees and managers or others who might encounter whistleblower reports should be educated on the whistleblower policy's requirements and rights, and also on how to react to them respectively. Lastly, organizations should indicate that the policy will be reviewed on a regular basis to determine whether it is working properly and whether any changes are needed. So in conclusion, whistleblowing is one of the most effective ways to uncover and stop fraud, corruption and other wrongdoing. Whistleblowers' revelations have revealed misconduct and fraud, assisted in the preservation of millions of tax dollars and helped avert environmental and health catastrophes. An organization now needs whistleblowing policies in order to attain effective governance status and develop a trustworthy corporate governance environment for all stakeholders. Further research on the effectiveness of current rules and regulations is necessary to better understand what works. These include how employees and the general public feel about whistleblower legislation and what initiative may be taken to foster the openness culture. That's all from us. Thank you for listening.